Morning, everybody, and welcome to today's webinar provided by Seashell Family Services, Parents and Carers Together Stockport, and Steve Broach, who is a barrister at 39 Essex Chambers, who specialise in the law affecting children and young people with disabilities. Today's webinar will be covering transitions to adulthood and will also include aspects of the Mental Capacity Act and the Care Act, and be delivered by Steve. As well as being a barrister at 39 Essex Chambers, Steve is also the co-author of Disabled Children, a Legal Handbook, which is published by the Legal Action Group. This morning's webinar will consist of two sessions. Session 1 will be from 10 until approximately 10 past 11, followed by a short break, and then session 2 will resume at 11:25 until 12:30 when the webinar will finish. Please can I ask that you use the Q&A function for any questions rather than the chat function. Please can you keep all questions anonymous, and the webinar will be recorded and available to view on the Seashell YouTube channel. I will now pass you over to Steve for today's session. Thank you.
Good morning, everyone. Thanks very much again to all those involved in organising today's talk. It's the last in our summer series of legal talks, which is sad to that extent, but I'm very grateful to have been invited back. And we were just talking about the possibility of doing more in the autumn, which would be great. So last but certainly not least, we're going to be looking at the issues around particularly the 16 to 25 age group today, often described as the transition age group, and probably the most complicated set of legal issues arise here because we're dealing with the interface between and the overlaps in two bodies of law, the law that concerns children and the law that concerns adults. So for those who are not clear yet, a child in law is anyone who's under the age of 18. That's certainly the case in the Children Act, and it's the case in international law as well. However, people will be well aware that the law starts to treat 16 and 17-year-olds differently in some very important ways, not least in relation to decision making. And one of the things we're going to talk about today is the implications of the Mental Capacity Act, which applies from a person's 16th birthday. So there's a 16 to 17-year-old cohort who are still children, but who are already beginning to be treated differently than their younger peers. And then from a person's 18th birthday, they are an adult. And for example, the Care Act directly applies to them. But they are still, of course, in many cases, particularly around disabled children and young people, going to need a very significant level of support. So there's no magic in a person's 18th birthday. So my task this morning is to try and unpick some of the tangle and make sure that people are left by the end of the session with a good idea of where you need to go to look for advice and support in terms of transition to adulthood issues and what some of the key legal principles are. As was mentioned, I'm a barrister at 39 Essex Chambers, and before I came to the bar, I used to work in the voluntary sector around disabled children and young people. Most recently at the Council for Disabled Children, where I set up the Every Disabled Child Matters campaign. And we did a lot of work in those days on the issues around transition to adulthood. I well remember when we did the parliamentary hearings on services for disabled children, gosh, 17 years ago now, 2005-06. The very graphic description of transition to adulthood was that it was like going into a black hole, that people just didn't know what was happening, what was going on. I think things have got somewhat better now, but still, unfortunately, very few people seem to have the smooth transition into adult life that the law expects to be the case. I can see there are some questions coming in on the Q&A, and just to say a couple of things. First of all, I can't give advice about any individual cases today. I'm sure people will understand that. I can only comment on general issues. So if you do want to ask a question, please do. It's very helpful to have questions, but please don't tell me about your individual situation, and please don't ask anything that's too specific to your own individual case. I can only answer general questions today. So that's the first point. Secondly, please keep them short because I need to try and read them as they come in. And that's quite challenging if I get a long question. And please do make them a question as well. Something with a question mark at the end rather than a comment would be appreciated. If there are any issues around the tech or any other issues people want to raise that aren't questions, feel free to use the chat, but please put any questions in the Q&A. That'll be very much appreciated. So I'm going to start just by showing you a couple of resources, and hopefully I'm going to be able to share my screen as I close down anything that's confidential. And the first thing I'll do, as mentioned by Simon earlier, is show you the handbook. So this is Disabled Children, a legal handbook, which was published in 2020, but still reasonably up to date. And I'm co-author with Professor Luke Clements, and we have a very eminent team of people who write the book with us. So there's lots of expertise in there. And the Council for Disabled Children very kindly funded the contents of the book going free of charge online. So as the link here shows us, you can also buy a hard copy or indeed a ebook on the Legal Action Group website. Legal Action Group are our publishers. And you can buy the book here somewhere. Here we go, print or an ebook. And you see it's £50, which is extremely cheap for a law book, but also still very expensive in the real world. So we very much recognize that. We very much wanted to support as many people as possible to access the book. And so we've put it free of charge on the CDC website. And importantly, this is what I'm coming up to, there is a chapter titled Transition to Adulthood. So really my job today is to try and summarize this chapter for everyone and go through the issues around transition in relation to social care, healthcare, mental capacity, briefly on housing, won't be able to spend too much time on that, and education. But of course, there's much more in the book here. So that, I think, will be the most useful resource for today's talk. So the starting point then for today, I think I'll start, as the book does, with social care. And part of the reason why social care is suddenly the starting point is that for many young people, education does still drop out at 18. Now, it doesn't have to, of course. And one of the key innovations in the Children and Families Act was to extend EHC plans to 25, where there is still a significant educational need. And that's the point, is that in many cases, it will be assessed that the young person doesn't need to continue to be educated post 18. Now, that may or may not be the right decision. And if it's the wrong decision, it can be challenged. And the EHC plan may well need to continue. But in any event, it's likely that social care input is going to be needed, not least because the young person may well no longer want to or be able to live at home. So things do change, of course, when a person turns 18. So we'll go straight on to look at the Care Act and what it says about transition to adulthood. So as people who've been on these talks before know, you can just put the title of the Act into Google or another popular search engine, and we're looking for the legislation.gov.uk website. So there is the Care Act. And importantly, what the Care Act did was bring together all the old law on adult social care and consolidate it and make it make much more sense. It's the product of very extensive work by the Law Commission and many others as well. And I would suggest it's a very good statutory framework. Implementation may be problematic, but in terms of the legislation itself, it's a very functional and sensible scheme, I would suggest. So I'm going to go through it, and I'm not going to start quite at the beginning here because I want to jump straight into how it deals, the Care Act, with transition to adulthood. And there's a section here, as we see, headed Transition for Children to Adult Care and Support. And the way that the scheme works is that children, as they approach their 18th birthday, are expected to be assessed applying the Care Act scheme. And we see under here, under section 58, what's called assessment of a child's needs for care and support. So where it appears to a local authority that a child is likely to have needs for care and support after becoming 18, the authority must, so it's a duty, if satisfied it would be of significant benefit for the child to do so, and if the consent condition is met, assess whether they've got needs for support, and if so, what they are, and whether they're likely to have needs for care and support after becoming 18, and if so, what they're likely to be. And that's called a child's needs assessment. It might be rather more helpful if it was called a transition needs assessment, but there you go. So that's the basic scheme of section 58, that there needs to be an assessment where it would be of significant benefit for the child to do so. And that's been taken and is just explained in the guidance as essentially being a question of timing. So when you do the assessment is judged by when it would be of significant benefit for the child, but it's got to be before their 18th birthday, somewhere around 17, one would think would be a sensible time generally, but well in advance of their 18th birthday, so that at the point they turn 18, there is already a decision in principle about whether the child should be eligible for care and support under the Care Act. And then there are equivalent obligations here in relation to parent carers And we'll see in a moment that the Care Act scheme works very differently for carers of young adults than it does than the equivalent scheme for parent carers of disabled children, in that you actually have a right to services as a parent carer or a family carer of a disabled young adult, and also young carers as well. So all of these provisions here from 58 to 65 are all about assessment, transition assessment as you move into adulthood. Also very importantly here, just nestling at the bottom of this part of the Act, is section 66. And as it's headed, this provides for continuity of services under other legislation. Now, it's extremely technical, and I'm not going to go through the technicalities, but it's worth noting that first of all, it creates section 17ZH in the Children Act. And what that does is govern the process of transition from children to adult care and support, where people are getting services under section 17. And what it provides is that those services under section 17 need to continue until the Care Act process is completed. And that means either that there's been a care and support plan produced which says the person's eligible and which shows how the needs are going to be met, or there's a decision taken that they're not eligible and they're not going to get any services under the Care Act. Until one of those 2 points has been reached, the children's package that's being delivered under the Children Act needs to continue. So there can't, in law now, be any cliff edge where someone is receiving services as a disabled child. Those services must continue until the adult process is properly concluded. People can't just fall out of the children's system and be banging on the door trying to get into the adult system. So that's a very important safety net. It's also there to allow children's services to continue, say, if a person's at a special school that runs to 19, until they leave the school when they're 19. So there'll be no sense, perhaps, in changing the care and support package just because the person's turned 18, and section 66 and the provisions that are created by it allow for that. So that's a very important starting point for this discussion. In terms of understanding how all that works, we've also got the Care and Support Statutory Guidance, which is the Care Act guidance, as you'd expect. And this is online in a reasonably useful way, in that you can click on the contents on the side here and see certain issues, the guidance on certain issues quite quickly. And you can also do a Control-F search for terms within the online guidance as well. Interestingly as well, it's very often updated. So we see here, this was updated yesterday. So you do need to check back and make sure that you're still relying on the current version of the guidance. And if I believe that we're dealing, where is our bit? I think it's here, is it? No, try to find the integration and partnership working. There it is. Section 16 of the guidance, transition to adult care and support. And we see that what this gives guidance on is sections 58 to 66, which we were just looking at. So the different bits of the care and support statutory guidance essentially flesh out the bones of the Act in terms of what the key obligations are in that area. And so we see that the chapter covers when a transition assessment must be carried out. That's the significant benefit point. Identifying young people who are not already receiving children's services, very important, because of course some children will be having all the support they need from school, but that won't happen when they're leaving school. Duties to adult carers and young carers, what should be in a transition assessment, cooperation, providing information and advice, age appropriate local services and resources, what happens once they turn 18, combining EHC plans with care and support plans, the continuity of care point, that's section 66, how safeguarding works after the age of 18, issues around ordinary residents, people moving into higher education, and transition to continuing healthcare, which we're looking at separately. So lots of the things we're going to cover today are dealt with in the guidance. I'm not going to go through the guidance now, just for reasons of time. We may come back to it later if time allows. So that then is our introduction. So the short points are: one, children's social care should continue post 18 until this process is concluded. Two, the way the process concludes is starts with a transition assessment of either the disabled child, parent carer, or the young carer. And then you go through the Care Act process to reach a decision on eligibility, and either a care and support plan is put in place if they're eligible, or a decision is taken that they're not eligible. So I'll pause there and see if there's any questions that have come in so far, which I need to deal with at the moment. So the question, so thank you for the other questions, which I will come back to many of. Is the transition assessment the same as the section 17 assessment? No, So a Section 17 assessment is an assessment of a child in need under Section 17 of the Children Act, which is the subject of one of our other talks. This transition assessment is for those children who've had a child in need assessment and are getting child in need services, or indeed other children are assessed through the Care Act scheme. So the assessment that's done is an adult social care assessment of, for example, a 17-year-old to indicate whether they're going to be eligible when they turn 18. Now, if their needs are stable, then obviously it will pretty much just be a straightforward yes or no applying the outcome of that assessment. But given that people's needs do change, it's not guaranteed that if you're assessed as eligible when you're 17 years and 2 months, you will actually be eligible on your 18th birthday. And so if things have changed, there may need to be another look. But otherwise, the transition assessment can stand as your first Care Act assessment as a disabled adult. Is the assessment under the Care Act obligatory? If not, how are those that need it identified? So no, it's not obligatory, because we've seen that there's a consent condition. You have to be asked if you are willing to have a Care Act assessment. And if you lack capacity, there's a process that you can go through to determine whether or not one should be done in your best interests. But what's interesting is, let's look at what the guidance says here about identifying young people who are not already receiving children's services. Here we go. This is all about the timing of solution benefit, right? So it says at 16.18 in the guidance, most young people who receive transition assessments will be children in need under the Children Act 1989 and will already be known to local authorities. May or may not be correct. They're certainly children in need. Whether they're known to local authorities is another matter. However, local authorities should consider, so they've got to think about how they can identify young people who are not receiving children's services, who are likely to have care and support needs as an adult. And the examples that are given: young people with degenerative conditions, young people, for example, with autism whose needs have been largely met by the educational institution. So, for example, a young person who's in a residential special school may not have any identified additional care needs because they're all being met by the institution, but they will need a significant amount of support once they leave school. And the other examples then are given here. And so the local authority has an obligation to think about who those groups are and suggest that they should have a transition assessment. But essentially, if a transition assessment is requested by the young person or their carer, then it must be carried out. We'll see in a moment the threshold for assessment is incredibly low under the Care Act. So yes, there's an issue for those young people who may lack a parent who's able to advocate for them, may not have another advocate. But otherwise, even if you've not been getting children's social care, then you should be able to get a transition assessment. If you are getting children's social care and your young person or yourself or your parent notice that you're 17 and no one's thought about a transition assessment yet, I would strongly suggest getting on the case about that and asking how that's going to be done in your local area. Unless, of course, you're extremely happy with the children's package and you'd like it to carry on, in which case you can just sit back and let them get on with it and keep the children's package while they complete the process. Potentially slightly risky because they may not necessarily comply with that obligation, but it's certainly a duty on the local authority to push forward the transition assessment, not the family. So that's that question. Just coming up here. So yeah, a question about needs, and which I'll come on to in a moment. See if there's anything else there. If a child's at a special school until 19, then the disabled children's team could maintain a children's package until then. Yes, that's right. So what Section 66 allows is a more phased transition. So there doesn't have to be a hard-edged 18th birthday, everything's got to change. What happens if a transition assessment doesn't take place? If a local authority goes straight to an Adult Care Act assessment? Well, essentially, that is a transition assessment if they're under 18. If they haven't done a transition assessment, then yes, by the time you turn 18, you just get an Adult Care Act assessment. But the short point is the package that you're getting as a child should continue until that process is completed. Excuse me. If you're not happy with the adult provision being suggested post-18, as it's not appropriate, can you insist that they stay where they are until 19, for example, in a residential sports school? Well, that's where it links to the EHC plan, because of course, while an EHC plan continues, then the local authority's got to secure the educational provision in the plan, and the institution that's named in it has to admit, and that can continue 19, 20, all the way up to 25. If the EHC plan ends, then it's highly unlikely that the child is going to be able to, young person, sorry, is going to be able to stay in a residential school or go to a residential college, because those are educational institutions. And then it would be about challenging decision making in relation to adult social care. So let's jump back then and look at the adult social care scheme and see. Now I'm still getting a few questions or comments on the chat, just to say, everyone, please don't do that if you can. If it's just a comment and you want others to see, that's fine. But I won't be answering questions on the chat. Let me just put the link in the chat as that's been requested. So this is the Care and Support Statutory Guidance, Chapter 16, and this is the Care Act that we're looking at right now. But as you've seen, these are all eminently searchable. I won't say Googleable, searchable. So then looking back at the Act, going to that to the beginning, we see that like most modern social welfare law, the Care Act starts with some general obligations, or as described here, general responsibilities of local authorities. So it's the local authority that has these duties. And the first is a well-being duty. So the general duty of a local authority in exercising a function under this part, so in doing anything in relation to adult social care under the Care Act, in the case of an individual, so it's about individual decisions, is to promote that individual's well-being. Now, I think that's fundamentally important, because I've been in court and had a judge say to me, this was a long time ago, to be fair, isn't social care just about keeping people safe, Mr. Broach? Well, now after the Care Act, the answer is obviously no, with respect, my lord, because the duty, the general duty, is to promote well-being, which goes far beyond basic considerations of safety. And we know that because Parliament's defined what does well-being mean. It means the individual's well-being so far as relating to any of these points: personal dignity, physical and mental health, protection from abuse and neglect, so that would be the more sort of baseline interpretation, control over day-to-day life, not choice, interestingly, but control, participation in work, education, training, or recreation. So that's really important. Adult social care is supposed to promote people's ability to do these ordinary things. Socioeconomic well-being, domestic, family, and personal relationships, suitability of living accommodation, and very importantly, the individual's contribution to society, their value to the community as well. So it's a very broadly defined concept. And then under subsection 3, the local authority has to have regard. So in all its decision making, the local authority must consider all of these things. So there's 8, I think it is, listed things that they have to take into account. The importance of beginning with the assumption that the individual is best placed to judge their well-being. So for all of these things, it's the person themselves as a starting point that gets to judge what will help them. And then to hammer it home, their views, wishes, feelings, and beliefs. And that's true whether or not the person has capacity, as we'll see in a moment under the Mental Capacity Act. The importance of preventing, delaying, and reducing needs. Making sure you only make decisions based on proper assessment, not on assumptions about the individual in terms of their age, appearance, their condition, or their behavior. The importance of full participation in decision-making by the person. And the reason it says individual is that this is about both disabled people and carers at this stage. Achieving a balance between their well-being and that of any relatives or friends. That's very interesting, I think. And we'll come back to that in a moment, because, of course, parental responsibility ceases at 18. And so no one is obliged to look after a disabled adult relative in the way that parents are obliged as a matter of parental responsibility to look after their children. And so we come into much more of a dialogue at this stage between the disabled person, the carer or carers, and the state through the local authority as to how needs are most appropriately to be met. The need to protect people from abuse and neglect, that doesn't go away, but it's not the only consideration. And then the least restrictive interventions principle, which again we'll see in the Mental Capacity Act as well. So there's a lot going on in section 1. It's a very important duty where decisions are made about individuals, and in terms of challenging decision making, referring to these points in section 1 and asking the local authority to explain how section 1 has been complied with is likely to be an important part of any challenge. So other points to note within the suite of duties here in part 1, I'll pick out, they're all important, but I'll pick out section 5 as well, because I think this is really key. So people will be aware, I'm sure, that the involvement of the market in NHS services is really controversial. When bits of service provision in health are taken over by private sector companies, there's often outcry, there may be media coverage, there may be a legal challenge. None of that is relevant in relation to adult social care, because the expectation is that local authorities will not necessarily provide any social care services themselves anymore. Instead, their duty, as we see here, is to promote the efficient and effective operation of a market in services. So that debate is ended by the Care Act saying, no, the local authority's job is to shape the market, right? Effective and efficient operation of a market in service for meeting care and support needs, with a view to ensuring that any person in the area wishing to access services in the market, again, can achieve these outcomes. So what we're looking for is a market that provides a variety of providers to choose from, who together provide a variety of services. So choice of high quality services. That's really important. The Parliament isn't saying there should just be a range of derisory or inadequate services. The services should be high quality, and that people get sufficient information to make an informed decision about how to meet the needs in question. And again, much like in section 1, the section 5 duty has within it these things that the local authority must have regard to. So the need to ensure that the authority has and makes available information about providers. So people need to know what the choice is in the market. A duty to be aware of current and likely future demand so that they can effectively shape the market. Enabling people to participate in work educational training, so services that point in that direction. Ensuring the sustainability of the market. There's some important provisions around local authorities intervening in case of market failure, provider failure. The importance of fostering continuous improvement in the quality of services and fostering a workforce whose members are able to deliver high quality services. And so what this all gets to is the concept of commissioning, local authorities having a key function of commissioning services and shaping the market in order to achieve these outcomes. And there's also a need to ensure, or having regard to the need to ensure that sufficient services are available. So there should be enough provision as well. And we see what else is here within the section 5 duty that follows. So that market shaping function of the local authority is absolutely key, and one again that local groups and other bodies need to be referring to if there's a gap in provision for example, autistic teenagers, then there may be a failure to comply with the section 5 duty that should be raised with the Director of Adult Social Care, the lead member, and so on. So that's what I was going to say in relation to first chapter in part 1. This then is really important. So before we even get to anything around assessment or anything, the Care Act starts in its substantive sections with this point about how to meet needs. And what's fascinating from a lawyer's perspective is the way that section 8 is drafted, how to meet needs. The following are examples of what may be provided to meet needs under sections 18 to 20, which are the duty and power to meet needs, as we'll see. And then the sorts of things you normally think of as adult social care are listed: care and accommodation or somewhere else, care and support at home or in the community, counselling and other types of social work, etc., etc. But these are only examples, and that's because, unlike the predecessor legislation, the National Assistance Act, Chronically Sick and Disabled Persons Act, when it applied to adults, there is no defined list of services that may have to be provided if certain conditions are met. Instead, the duty is much looser textured. It's a duty to meet need. Now, that has real strengths and weaknesses, I think, from a service user perspective. On the one hand, you're not fettered and not confined to these traditional forms of services. But on the other, it's much harder to enforce a particular entitlement to a particular service because the local authority just has this much more generalized duty to meet your needs in the way that it thinks is appropriate, taking account of your views. So the strengths and weaknesses in that approach, but that is the approach the Parliament has mandated. So how do we get there? Well, first of all, we start with the assessment duties, and we see in section 9 the duty to assess an adult's need for care and support. So this is the duty for disabled people. So it's very, very straightforward. Where it appears to a local authority that an adult may have needs for care and support, that's the threshold, that's the test, that the person may have needs for care and support. If that test is met, then the authority must assess whether they do have needs and what they are, if so. And that's a needs assessment for the purpose of this act. And just to hammer it home how low the bar is, that duty applies regardless of the authority's view of the level of the needs for care and support. So even if the authority is absolutely convinced this person isn't going to meet the eligibility criteria, they still have to do a needs assessment. So it's essentially an on-request duty to assess. It's very hard to imagine a situation where someone would ask for an adult social care assessment and needs assessment under the Care Act, and they don't even at least appear to have some needs for care and support, or the potential to have needs for care and support, because we see it may have needs. So it may as well, I would suggest, be an on-request duty. And we see what's in headline terms required of an assessment defined in the rest of the section. Now, there isn't a mandated form for a Care Act assessment of a disabled person. It doesn't have to necessarily be a face-to-face assessment. It doesn't necessarily have to follow a particular format. What's essential is that the outcome of the assessment is proper identification of needs in a way that is appropriate, and the process must be appropriate for the person's own wishes, feelings, capabilities, and so on. So that's section 9 in relation to adults. And then section 10 is the assessment criteria for carers, and it's very similar. So where it appears to a local authority that a carer may have needs for support, whether currently or in the future. So again, you don't even have to potentially have needs now. You can potentially have future needs. And we see here it's for support. So care and support is the composite term for disabled people. For carers, we talk about support in their caring role. Then the local authority must assess whether they do have needs, and if so, what they are or are likely to be. And that then becomes a carer's assessment. So it's a very similar process. But it is, I think, very interesting what the carer's assessment must include here at subsection 5, whether the carer is able and is likely to continue to be able to provide care, and whether they're willing and are likely to continue to be willing to do so. So suddenly, because we're now post-18, this concept of willingness is introduced. You don't have to do it. It's a voluntary choice to provide care. And if you don't choose to provide care, then if the person has eligible needs, the local authority will have to meet them all. The problem, of course, is they may not choose to meet them in the way that you would want. And so there is still a very important need for a dialogue. I wouldn't advise families simply just saying, no, I'm not doing anything, over to you, unless you're happy to leave it to the local authority. But you are, I would suggest, entirely entitled to say, well, I'm only willing to provide care on Mondays, Wednesdays, and Fridays because I work on Tuesdays and Thursdays, for example. Otherwise, and you might articulate that as able if it's essential that you work for whatever reason. So, as it very often will be, of course. So that's the carer's assessment, the extra twist in carer's assessments in section 10 that I wanted to highlight. The next point to pick up is the eligibility criteria. There is, of course, regulations and guidance underpinning the details of assessment, but I won't be going into those today just for reasons of time. So in terms of what happens next, once they've done the assessment, what the local authority has to ask itself is whether the adult has needs for care and support. And assuming it does agree they have some needs for care and support, what happens next is they must determine whether any of the needs meet the eligibility criteria. See subsection 7, we'll get there in a minute. They've got to make that decision, they've got to write it down. Where at least some of the needs meet the eligibility criteria, the local authority must consider what could be done to meet them, ascertain whether the person wants those needs met by the local authority, and then check out ordinary residents. Similar for carers. If none of the needs meet the eligibility criteria, then the person's supposed to still get advice and information about what can be done to meet or reduce needs and prevent development of future needs. And we see that under subsection 7, the needs meet the eligibility criteria if they are of a description specified in regulations. So at this point, we do need to go off to the regulations. Eligibility criteria regulations. I think it's 2015. Yes, here we go. So these are the eligibility regulations, and you see they're very short. There's only 2. One's for disabled people, one's for carers. And we'll look briefly at the disabled people's regulations. So we know, we've just seen in the Act that the needs meet the criteria if they are of a description specified in these regulations. So an adult's needs meet the eligibility criteria if, 1, they arise from or are related to a physical or mental impairment or illness. Well, that's not particularly difficult. In the vast majority of cases we're concerned with, there'll be a big tick next to 2(1)(a). B, as a result of the adult's needs, the adult is unable to achieve 2 or more of the outcomes specified below. So there's a few things we need to unpack in here. Let's go backwards. The outcomes, we see them listed here from A to J. And they are the kinds of ordinary life activities that you would expect: eating, hygiene, toileting, dressing yourself, etc. But also some slightly more sophisticated concepts like maintaining a habitable home environment, developing and maintaining family or other personal relations, accessing and engaging in work training, educational volunteering, making use of community facilities, and parenting. So all of those are areas of outcomes which can result in eligible needs. So if as a result of your needs, you're unable to achieve these outcomes, at least two, then that gets you most of the way through. Now, when the regulations were being considered, there was initially just one, and it was up to two to try and make it slightly harder to be eligible. But I've never met a disabled person in reality who only has real difficulties in one of these areas. So I'm not sure that making it two or more did actually achieve a significant reduction in the number of people with eligible needs. Because, for example, if you can't feed yourself, you're unlikely to be able to maintain your personal hygiene. If you can't develop and maintain family and other personal relationships, you're unlikely to be able to engage in work training, educational volunteering. So they're quite linked, a lot of the needs, a lot of the areas of outcome. It's conceivable that someone could only have one, but unlikely, I would suggest. The next point to stress is this word unable, because that sounds quite difficult, obviously. And inability sounds quite a high bar, but it's defined here in paragraph 3. For the purpose of this regulation, an adult is to be regarded as being unable to achieve an outcome if they're unable to achieve it without assistance. So hang on a minute. If I can do something like dress myself, but only if someone helps me, I've just become unable to do it for the purpose of this regulation. So that sounds rather more promising. Or if I'm able to do it without assistance, but it causes me significant pain, distress, or anxiety, I'm eligible. Or if I can do it without assistance, but it puts mine or someone else's health or safety at risk. Or even if I can do it, but it takes me significantly longer if I do it on my own than would normally be expected. So really that word unable, I think, is rather unhelpful in the regulation, because as defined, it doesn't mean anything like the ordinary meaning of inability. It means finds difficult. So it could properly be read, I would suggest, as find difficult in any of the 4 ways described. Then you are eligible. At least you've got through the next limb of the eligibility test. So that's 1B. And then finally, as a consequence of the above, so a consequence of having needs relating to your physical or mental impairment or illness, which makes you unable to achieve 2 or more of the outcomes, there is or is likely to be a significant impact on your well-being. So well-being has that broad meaning that we saw defined in section 1. Significant means more than minor or trivial. It means something that you notice. So it's not, again, a particularly high bar. So stepping back, I would suggest that a large number of disabled young people, autistic young people, for example, when that test is properly applied to them, will have eligible needs. And so they will have needs that meet the eligibility criteria. So that's the eligibility criteria in broad terms. And there are similar criteria. In fact, let's look at them because they are important for this purpose. You've also got, sorry, go back to the beginning, the criteria for carers as well here. Sorry, let me just put the link to the regulations in the chat. People can just find it if they're not able to follow along. Okay. So the carers test is similar. The carer's needs meet the eligibility criteria if the needs arise as a consequence of providing necessary care for an adult. So I can imagine that there might be some argument about whether the carer is providing necessary care. The effect of the carer's needs is that any of the circumstances specified in paragraph 2 apply. Now, here we only need one, so it's any of the circumstances, and those are a risk, at least, of deterioration in physical or mental health. Well, tick, very often that alone will be present. And then, if not that, or in addition to that, an inability to achieve any of the following outcomes, which broadly track the outcomes that we've just seen. And again, inability is defined as being unable to achieve without assistance, significant pain, distress, or anxiety, or endangering health or safety. We don't have here, it takes you longer as a form of inability. So it's very similar, but not the same as the approach for disabled adults. And then finally, again, that as a consequence of this, there is or is likely to be a significant impact on the carer's well-being. and importantly, where the carer's needs fluctuate in determining whether the carer's needs meet the eligibility criteria, the circumstances must be taken account of over an appropriate period of time. So that's eligibility for carers, which means that, again, as we're going to come to, carers may have a right to services under the Care Act in a way that they didn't have before, and the parent carers of disabled children still don't have. So all of that was based on what's said in section 13 about the eligibility criteria. So I'll skip over charging and financial assessment for now, move on to the duty to meet needs. So we see here in section 18, so arguably the most important section of the Care Act, this duty to meet needs. And a local authority, having made a determination under section 13.1, so that's the eligibility decision. So having gone through the process of assessing needs, deciding whether the person has eligible needs, they must meet the needs for care and support for the disabled person. If they're ordinarily resident, their costs don't exceed the cap on care costs, which people may have seen is being introduced at the moment, and there's no charge under section 14, or if there is a charge, relevant conditions are met. So subject to considerations of ordinary residence and charging, if the person has eligible needs, they must be met. And that's what section 18 says, but it doesn't say how to meet them. And as we've just seen in section 8, there's this broad list of examples of the ways that need may be met, but no defined requirements in this legislation. And then in section 20, we have the equivalent duty in relation to carers. So this is the really novel bit. A local authority, having decided under section 13.1, must meet, so duty, a carer's needs for support which meet the eligibility criteria, again, in consideration of ordinary residence and charging are met. So it's an important new entitlement for family carers of disabled young people once they've turned 18. And there's also, of course, powers to meet needs where the duty isn't triggered, but in the current climate, it may well be unlikely that those powers would be exercised for financial reasons. We see there are a number of exceptions. People subject to immigration control, ordinary housing should be provided under the Housing Act, of course, and importantly, health services. So a local authority may not meet needs under section 18 to 20 by providing or arranging for the provision of services and facilities that would be provided under the NHS Act, unless it's merely incidental or ancillary to providing ordinary social care. And so that means that there is a hard-edged line, sometimes it can be quite hard to find, between social care and healthcare, and that's what the National Framework for NHS Continuing Care helps us identify, and we'll come on to that later on. So then going back to charging, as we've seen that that's important in order to get into the duty, we see that under section 14, local authorities have a power to charge. They're not required to charge anymore, and they must make a decision about whether they're going to charge. And there are certain things like reablement services they're not allowed to charge for. But the vast majority of local authorities, Hammersmith and Fulham is an exception, do choose to charge for all the things that they can charge for under section 14. And the way that the charge is worked out, skipping the cap because that's still not in force, is through an assessment of financial resources. And so what the local authority must assess is the level of the adult's financial resources and the amount, if any, which they're likely to be able to pay towards the cost of meeting the needs for care and support. Now, the process of calculating that is extremely complicated. And if we look at the Care and Support Statutory Guidance again, so I'm just going to go back to the beginning, hopefully this will do it. Yeah, we see that there are annexes that are very important on this, one of which governs the treatment of income for charging purposes, and the other of which governs the treatment of capital. And so if you're concerned about charging, very important to look at annexes B and C of the guidance, which will support you to understand whether certain capital or income must be disregarded. There are some extraordinarily lengthy regulations that govern all of this. There is, of course, a main chapter on charging and financial assessment as well. Here we go in chapter 8 of the guidance. But often the devil is in the detail, and that detail is found in the annexes. I think I'll pause there, just have another look at the questions. We've gone quite a long way into the Act before I get on to all these next steps duties. See if there's any questions that need to be answered or that I haven't managed, that I'm not coming to. So some of the questions that are good questions that I need to deal with, but they are things I'm coming to shortly. Do carers have to have a financial assessment and contribute to the cost? Potentially. So local authorities can charge for carers services. Many choose not to. And if I recall, the guidance suggests that they don't, on the basis that it's important to support carers because otherwise they might stop caring. So again, that's a matter for each local authority to decide. Does the adult that's being cared for have to have eligible needs for the carer to be eligible? Great question. So let me just go back to the eligibility regulations on that. So we see that the needs arise as a consequence of providing necessary care for an adult. And so the problem may be that if the adult hasn't got eligible needs, the local authority may not accept that the care that's being provided for them is necessary, but they may. So my understanding is, let's see if the guidance helps on this. But the strict answer is no. Identifying needs. There. Yeah, I think it's in there. Yes. That's assessment. Let's go through that. Everyone close their eyes. So I'm going to do some scrolling. To look at what the guidance says about carers eligibility. This is quite important because I mentioned before, assessments can be in various different forms, and what's required is that the assessment process should be appropriate and proportionate for the person's needs. Scrolling through, apologies. To perhaps do with rather more clickable links within the guidance. Okay, so here's eligibility. We see the national eligibility criteria set a minimum threshold, and we've looked at what the threshold is for adults and the guidance on the various points there. And just going down now to carers. Important point here, considering needs met by carers in eligibility determinations for the adult, the eligibility determination must be based on the adult's needs and how these impact on their well-being. Authorities must only take consideration of whether the adult has a carer or what needs may be met by a carer after the eligibility determination when a care and support plan is prepared. So you essentially need to discount the carer's input at the point of needs identification and eligibility. So what's the national eligibility threshold for carers? Carers can be eligible for support in their own right. We see that. Got to be all three of these conditions. So necessary care for an adult. Local authorities must consider whether the carer's need for support arises because they're providing care to an adult. And here's the answer to the question, and it's what I thought. Carers can be eligible for support whether or not the adult for whom they care has eligible needs. But it is obvious, I would suggest, that if the person has eligible needs, it's more likely that the local authority is going to accept that they're providing necessary care, as is the test at this stage. If the carer is providing care and support for needs which the adult is capable of meeting themselves, the carer may not be providing necessary support. So that's how that's dealt with. A few points about moving area, which I will deal with in a moment. Just going to give people the Disabled Children Legal Handbook link, because that's been requested. Put that in the chat now. If a family carer says they would like support with their emotional well-being, would the local authority need to provide this directly or fund the service, as they have a general duty to identify carers' needs? Well, if that was accepted to be an eligible need, then the local authority would have to meet it. But how they meet it, as we've seen, and as we're going to go on to see in more detail, is really a matter for them once they've taken account of the person's views. So they could do either of the things that the question suggests, or they could do something else. Okay, so going on to the care and support planning process. So the next steps duties. So what we see in section 24 essentially is that the Act takes a breath and says, okay, we've got this far. The local authority is required to meet the needs under section 18 or 20, or it decides to do so under the powers, it must. So then do certain things. Prepare a care and support plan for the disabled person or a support plan for the carer. Tell them which, if any, of the needs that it's going to meet may be met by direct payments, and help the adult with deciding how to have the needs met, which sounds rather lovely, but I'm not sure that really that's a very accurate description of what happens, because of course it's not up to the person unless they've got an infinite amount of resources to decide for themselves. If they're not required to meet needs and aren't going to exercise the power, there must be written reasons for that, and then advice and information on preventing and reducing needs as well. So that's section 24. Then we have in section 25 the description of a care and support plan. So I think it's quite important to note that the needs assessment and the care and support plan are two very separate documents, or should be two very separate documents under the Care Act. Not always the case in practice. They could conceivably be in one document, one physical document, in that the plan could follow the assessment, but they're doing two very different things. The needs assessment is identifying needs. The care and support plan is the process of working out how the needs are going to be met. And so we see that it's a document prepared by a local authority, so it's owned by the local authority, which specifies the needs identified by the needs assessment or carers assessment, specifies whether, and if so, to what extent they meet the eligibility criteria, specifies the needs the local authority is going to meet, because of course some eligible needs will be met by other people, most obviously carers, and how it's going to meet them. Specifies in relation to a reduction of and prevention of needs, includes the personal budget. So if there has to be an identified allocation of funding, as we'll see in a moment, and various other matters as well. All of that must be in a lawful care and support plan. And if there's direct payments, which needs are being met by direct payments must be specified, and the amount and frequency. And of course, in preparing the care and support plan, the local authority must involve the person, any carer, and any person who the adult asked to be involved, or if they lack capacity, anyone who appears to be interested in the adult's welfare. And very importantly here, the local authority must take all reasonable steps to reach agreement about the plan. So although it's owned by the local authority, they must really try to agree it and to take it. So that means they've got to take into account the person's views. And if they're going to depart from what the person wants, they'll need to explain why and try and seek agreement. But ultimately, it is their plan. They get to decide. So that's the essence of the duties in relation to care and support plans. Section 26 then deals with personal budgets. So what is a personal budget in the adult social care context? It is a statement that specifies the cost to a local authority of meeting the needs that it's required or decides to meet, the amount which on the basis of the financial assessment the adult has to pay, so the charge, and essentially what's left if the local authority is paying anything itself towards the cost. So it's a calculation of the cost of the package that will be required to meet the person's needs minus the charge. It doesn't necessarily, of course, mean that that will be delivered through a direct payment. A direct payment is one form of personal budget. It's, as we see here in sections 31 to 33, there is specific provisions around direct payments. But that doesn't mean that anyone is entitled to a direct payment, because what we'll see if we look at, for example, at those who've got capacity, is there are various conditions that have to be met before you get a direct payment. And the last of them is that the local authority is satisfied that making direct payments is an appropriate way to meet the needs. And they might say, well, it's not appropriate because we can do it more cheaply through providing our own commission service, and we think that's appropriate. Now, in many cases, that won't be what local authorities say, because they're set up now, geared up to make a direct payment. But it's at least open to a local authority to consider and determine whether there is a more appropriate way to meet the person's needs. At the same time, a local authority can't force a person to take a direct payment, because if you take on a direct payment and then use it to employ a personal assistant, for example, you're entering into an employment relationship. People can't be made to become employers. So you're entitled to say, no, thank you, I don't want a direct payment. I want my needs met another way. But if you want a direct payment, you will probably get one, but there's no absolute right to it. Otherwise, the personal budget could be notional, in that the local authority just keeps the money and commissions the service, or it can be transferred to a third party. So direct payments and personal budgets are not synonymous. A direct payment is one type of personal budget. There's then provisions for reviews, as you'd expect. Now, some of the questions were about people who move around, move between different local areas, and there is a degree of portability in the Care Act scheme, but it's not particularly strong from the perspective of the disabled person or the carers. Essentially what happens is that where a person's needs are being met by a local authority, and that person tells the next local authority, or they find out that they're going to move into their area, and they're satisfied that's a genuine intention, there has to be a process of dialogue between the two authorities, and they must transfer over the care and support plan and so on. But they don't necessarily, we see here, the second authority must assess the needs for care and support and essentially carry out their own process, having regard to what's been done before, but they don't necessarily have to follow what's been done before. So although there is provision here to avoid people, again, falling off a cliff if they move, it doesn't mean that you're going to necessarily keep your package of support as you move between different areas. Then there's provisions around ordinary residence. Ordinary residence is not necessarily a straightforward issue, and it's probably more complicated than I've got time to explore today, I'm afraid. It's definitely an area where if there's any issue raised about ordinary residence, people are going to need to seek their own advice. What's also new and important about the Care Act is these provisions here in relation to safeguarding, because until the Care Act, we didn't have any legislation in relation to safeguarding of vulnerable adults. It was only for children, and all of the adult safeguarding issues were under the inherent jurisdiction of the High Court and under the no secrets guidance. But now we have this duty in section 42 on the local authority to carry out safeguarding inquiries if they've got reasonable cause to suspect that an adult has needs for care and support, is experiencing or is at risk of abuse or neglect, and is unable to protect themselves against that risk. And that inquiry may result in a number of different kinds of action being taken. For example, an application may be made to the Court of Protection or under the inherent jurisdiction of the High Court for a protective order. The police may be informed. The local authority may start providing or offer to start providing care and support themselves, and so on. What there isn't is any kind of safeguarding power or duty to actually provide services or do anything. It's a duty in relation to make inquiries. And we see, in fact, that in section 46, the power to remove persons in need of care was abolished. So that's quite interesting that there isn't a sort of overriding safeguarding power given to local authorities. I mentioned the issues around provider failure and market oversight before. I won't go into that now. We've looked at the transition provisions already. Advocacy, very important. So the Care Act creates a statutory right to have an advocate where a person is experiencing substantial difficulty in engaging in the Care Act processes around needs assessment, care and support planning, and so on, in relation to the areas that people may well be familiar with in terms of the Mental Capacity Act. But that duty doesn't apply if there's a person who's appropriate to take on the role and who isn't engaged in providing care or treatment for pay. So very often a family member will be playing that role. But if there's not an appropriate person, then the local authority must appoint an advocate to support the person, generally the disabled person, but potentially also the carer, to engage in the care and support planning process. And then in terms of other provisions to mention, section 78 in terms of the guidance tells us that this is Act under guidance, which is the highest form of statutory guidance. So the care and support statutory guidance is something that local authorities must follow in the absence of a considered decision that there's good reason not to do so, which is, I've never in all my years of practice known a local authority try to argue they've got one of those. So if it's in the guidance, essentially it must be done. It has very significant legal weight. And the other point I wanted to make, which is a technical one, but an important one, is that section 73 of the Care Act means that private and voluntary sector providers of adult social care under the Care Act, subject to a few conditions, are people to whom the Human Rights Act applies. And at present, we still have the Human Rights Act, and it mandates that public authorities must act in accordance with everyone's human rights. And following a House of Lords decision, that didn't include private sector providers of, for example, care homes. But section 73 is the second statutory provision that reverses that decision of the House of Lords and says they are covered while they're providing regulated care or support. So you can bring a human rights claim against a charity or a private provider of adult social care if you consider that they are failing to act in accordance with the person's human rights. And that's a very important safeguard, I would suggest, indeed. Okay, so I'll go to the questions for the last 10 minutes before our break. And then when we come back, we'll be looking at NHS Continuing Healthcare and the Mental Capacity Act as our two key themes for the rest of the talk. So there was a question about financial parental responsibility. I'm afraid that's outside the scope of today. I'm not going to be able to answer that today. The question, can a young person who lacks capacity go into supported living? Yes, absolutely. And we'll see that decisions for people who lack capacity will be made on a best interest basis. And very many people in supported living settings will lack capacity to decide where they live. And their best interest will be protected by a placement in a supported living setting, either because everyone agrees that's what's right, or with the Court of Protection deciding if there's a dispute. Can an education, health and care plan continue into university? No, it cannot. At the moment, EHCPs are only available for schools and FE colleges. There is no entitlement, no power for the EHC plan to continue if the person is moving into higher education. There are still some supports for higher education, disabled students allowance and so on. And universities, of course, have all the Equality Act duties as well. But EHC plans do not continue post 25 and not into higher education. Can speech and language therapy be included in the care plan of a person who's aged over 25? A great question, because of course, speech and language therapy in the EHC plan context is almost always educational provision. So what happens once to your need for ongoing therapeutic intervention once you've turned 26? The answer is that those will probably be seen as health services post 25. And so you need to be engaging with your clinical commissioning group as to whether or not it's accepted that there's a need and if they're going to provide the service. The problem is that the duties in relation to the NHS are much broader and looser textured than they are in relation to EHC plans. And so it may be harder to enforce any kind of entitlement to therapy post 25. I think I've dealt with the question about set criteria for need. So there is now national eligibility criteria, as we've seen. Before the Care Act, people might have heard of something called fair access to care services or prioritising need, which set bands of needs, critical, substantial, moderate or low. That's all gone. And so there's now only this national criteria that everyone has to apply. So in theory, if you've got eligible needs in one local authority, you will in another. But of course, it's still a matter of judgment as to whether or not you meet the criteria, and different local authorities might reach different judgments on those. What's a child in need service? It's a service that's provided under Section 17 of the Children Act to a disabled child, in our case, or another child in need. A few other questions there that I think are too specific for me to deal with at the moment, just looking through. When it says, when a duty says that something must have regard, someone must have regard to something, does it mean they have to do it or just have to think about it? Great question. It means the latter. So it's very important to note that, for example, in Section 1, in the wellbeing duty, all those things that local authorities must have regard to, they're things that have to be taken into account in the decision-making process. They're things that if they're ignored would make the decision-making process and the resulting decision unlawful, but they're not necessarily outcomes that have to be achieved. The local authority can consider those points and do something else or deliver a package that doesn't necessarily result in those outcomes, as long as they've given them proper consideration. In terms of challenging local authorities that are failing to do some or all of these things, what are the options available? Well, the most straightforward option, of course, would be to make a complaint, and the complaint would then go on to the local government and social care ombudsman. And sadly, many people do have to go down that route. What about if you've got a very serious problem, an urgent case, where someone's needs are going unmet? In those situations, or if you've got a policy challenge where you think the local authority is systemically doing something unlawful, the remedy might be judicial review instead. And for that, you will need to contact a solicitor, probably a solicitor with a legal aid contract, and you will need to be eligible for legal aid. If you're not eligible for legal aid, it will be very difficult, I'm afraid, to fund a judicial review. So I'll put the list to the link to my blog on solicitors who have relevant contracts in the chat now. Look at that if that's of any interest. But yes, the choice will really be a binary one between either making a complaint or bringing an application for judicial review. There is as yet no Care Act appeals process. There could be one. There could be a tribunal set up, but that hasn't been taken into effect yet. Should carers assessments and assessments of the disabled person be separate? Yes, they should, because the questions are different. As we've seen, the eligibility criteria are different. So there has to be a carers assessment, there has to be a disabled person's needs assessment. Could they be in the same document? Probably. Is that helpful? Possibly not, because it tends to confuse. I would suggest having separate assessments would be better. So a question about ordinary residence, if someone needs to move out of county to a provision needed to meet their needs that aren't available in county. Well, if you're placed in a particular placement by a local authority, then subject to a few exceptions, the likelihood is that the placing authority will continue to be responsible for paying and for meeting your needs. But those questions about responsibility of ordinary residence, as I say, are going to require very careful case-specific advice. Question about independent social workers. If someone was to instruct an independent social worker, what would be the areas to ask them to focus on? Well, if you're in the happy position of being able to instruct an independent social worker, you'd obviously want them to essentially carry out the Care Act assessment and to assess against all the relevant areas of need and the outcomes that are specified in the eligibility criteria, and determine whether or not, in their view, the person has eligible needs. So that's I think where you'd want to go. Of course, unfortunately, many people would not be in a position to fund an independent social work assessment. It shouldn't be necessary. It is worth noting that if you get certain forms of legal aid, you may be able to get an independent social worker funded via legal aid. Again, you will need a solicitor to advise about that. If you're able to fund an ISW, as they're known privately, then happy days. But it is an expense, of course, that will be beyond the very large majority of people. Can difficulties arise if you move to a different local area? If the new local area has different ideas about what's a reasonable offer? Yes, I think that's right, because the Act doesn't mandate that needs are met in a particular way. And so there is always going to be room for disagreement, judgment as to what the needs are, whether they're eligible, and how they should be met. Of course, it does say that the local authority's got to take account of the previous package, but it doesn't necessarily have to comply with it. So yes, that is definitely a consideration in terms of moving around the country. What legal principles does the local authority have to use to decide whether to fund a residential college placement? Well, of course, a residential college will primarily be an education-focused provision. And so applying the principles from the Children and Families Act, it's likely that that's going to be more expensive than a day provision. And so there would have to be an agreement, or the tribunal would have to order that the residential college is necessary to meet the person's educational needs. Or alternatively, the local authority may accept that although in principle the educational needs can be met by a local provision, but the overall social and other needs require residential provision, and that's appropriate as a form of education too. If the local authority doesn't accept that and you want to rely on a social reason as opposed to an educational reason for residential, then the remedy would have to be judicial review, and you probably have to show that the local authority's view is irrational, which is a very high threshold to get across, essentially that no reasonable local authority could have taken that decision. So again, those are sorts of cases where specialist advice is definitely going to be necessary. Just going through some more questions. So I think I've answered the question about what could be done about non-adherence to any of this. The remedy will be judicial review. Given the shortage of carers nationally, can parent carers refuse to take on responsibility of direct payments and put the responsibility back on the local authority? Yes, absolutely. I'm not aware of any mechanism that allows a local authority to say the only way in which we will meet your needs is to offer a direct payment. As far as I'm concerned, but for both children and adults, it's entirely open to the recipient to say, no, I don't want a direct payment, thank you, I'd like you to meet the needs. Of course, then how the needs are met will fall to a local authority to ultimately decide. Have to take into account your views, but I'm not aware that the offer of a direct payment alone is an adequate way of discharging duties to meet eligible needs. Is there a template document of a care and support plan, or does it vary? It does vary locally. Great question. Of course, within the care and support statutory guidance, go back to that for a moment, there's a section on care and support planning, purposes of the care and support planning. So we see here in chapter 10, care and support plans, how to undertake it, the production of the plan, etc., combining plans. But what it doesn't say is this is what a care and support plan needs to look like. So essentially, I would suggest you read chapter 10, add the guidance, and you can then audit any care and support plan that you've got against the guidance to see if it is adequate. Hopefully I've answered the question about the difference between a personal budget and a direct payment, that a direct payment is part of a type of personal budget, sorry. Great question here. Should a local authority be using the indicative budget to put a hard limit on the personal budget? No, very much not. See KM and Cambridgeshire. So in the Supreme Court case that I was involved in 10 years ago now, the Supreme Court said that things like resource allocation systems, RASs, indicative budgets are all fine as a ready reckoner, as a form of estimating the cost of the package. But at the end of the day, the duty is to meet needs. And so the amount of money that you're going to be given, if it is a direct payment, and the personal budget in any event, must be adequate to meet the needs. You cannot say, for example, that the maximum hourly rate is £9.50 an hour, because someone may not be able to have care from a person who will accept that level of payment. So the local authority has to satisfy itself in every case that the eligible needs can be met by the amount of funding that has been given. Do all support plans have a personal budget attached to it? They should, because we've seen that there is a duty to calculate a personal budget in every case. Right, I think I'll stop there. Thank you for the questions. I'm going to move on to the Mental Capacity Act, as I say, after the break, but also before we get there, a quick stop by NHS continuing healthcare, because that will deal with a few other questions. I've just spotted one at the bottom I can take very quickly. Legal aid calculation once person's turned 18 is based on the person's resources, not the family's. So it may be worth looking again at whether an adult's child is eligible for legal aid if they were told no as a child. Thanks everyone. We'll have a short break now and come back again at 11:25. Hi everyone. Hope you managed to have a short break, to coin a phrase, and that you are feeling refreshed, ready to go for the second half of the talk. We'll move on to look at continuing healthcare and mental capacity issues in a moment. But there's a couple of questions I have to answer quickly that have come in that I need to deal with urgently. One is, to be under the adult disability team, they're insisting on the person having an IQ under 70. I thought we'd got rid of that kind of thing. Very interesting if that's still going on. I would strongly suggest that anyone who's told that there's any kind of IQ threshold for anything gets some legal advice as quickly as possible. I think I'll leave it there. Should the process for adult care and support have started by the time the person turns 17? Yes, generally speaking, I would say so. If it hasn't started by the time the person's turned 17, alarm bells should start ringing, and it should certainly be starting very soon after that, because the whole point is there shouldn't be a rush to complete the process just because of the arbitrary fact of when the person is turning 18. Right, so I'll look now at the issues around continuing healthcare, and for that we're going to go straight to the guidance, because it's the most straightforward way of explaining what is quite a complicated process. So if we put in NHS continuing healthcare, a little bit more than that, let's put in national framework as well. That's where we need to go. So again, we'll do the link here in the chat. I'm being asked about whether the session is being recorded. As I understand it, it is, and it will be put on the Seashell Trust website. So this is the national framework, as it says, for NHS continuing healthcare and NHS funded nursing care. Let's see what it tells us. First of all, the thing we'll notice is 187 pages long. So it's not at all concise. And that really does, I think, exemplify how complex the national framework is. And interestingly, we see that it's been revised at a date that hasn't yet arrived, which is July 2022, published in May 2022. So it replaces the version that was published in March 2018. This is the new, we'll look at the new version then. I don't think there's anything here that is radically different to the old version. And it says, importantly, none of these amendments are intended to change the eligibility criteria. So it shouldn't change who would be eligible for NHS funded continuing care. So just looking at this, at the summary, of course, we see how much detail there is in here. And we'll come back to the transition chapter in a moment. So it deals with the principles and processes, as it describes it, of continuing healthcare and NHS funded nursing care. At the heart of the national framework is the process for determining whether an individual is eligible, and they are eligible for continuing healthcare if they have a primary health need. And that's a concept developed by the Secretary of State for determining when the NHS is responsible for providing, and this is important, for all of the individual's assessed health and associated social care needs. So where a person has a primary health need and is eligible for continuing healthcare, then the NHS becomes responsible for meeting all their needs, essentially. It's only if they don't have a primary health need, but they require some nursing care, that there can be a joint package of nursing care funded by the NHS and other care funded by the local authority. And to reach that decision, a detailed assessment and decision-making process must be followed, as set out in this national framework, which is underpinned by, as it says, the regulations, which are then issued under the Act, and therefore it's statutory. The framework is statutory. And the relevant bodies, which will become integrated care boards, have to have regard to the national framework. And we saw a little while ago, Section 22 of the Care Act, which preserves the existing boundary and limits of local authorities' responsibilities. Important that the process should be person-centered, as it says here, and these are the definitions. So continuing healthcare is a package of ongoing care that's arranged and funded solely by the NHS, where the individual has been assessed and found to have a primary health need. For people aged 18 or over, so if children get NHS children and young people's continuing care, which is a similar concept but operates in a somewhat different way. So we're focusing now on the adult process, not determined by the setting in which the package of support can be offered or by the type of service delivery. It's determined by the level of need, as we see. Just scrolling on then to find the next bit that I wanted to take you to. As we see, if they're not eligible for continuing healthcare, they may still have responsibility to contribute. And that's where we get the joint package of care concept. So what the integrated commissioning boards, currently the CCGs, will have to do. NHS England does, including dealing with independent review panels if there's a challenge to a decision on eligibility. And moving on. This is a summary of the legislation. So all this is being done under sections 1 and 3 in particular of the NHS Act, and then the regulations that mandate regard to the its guidance. No legal definitions of health and social care needs, but we can see the commonly used definitions as you would expect. Primary health need threshed out in a little bit more detail here. And what's important, I would suggest, is this section here. Determining whether an individual has a primary health need involves looking at the totality of the relevant needs. An assessment must be undertaken by a multidisciplinary team, the MDT, which must use the National Decision Support Tool. So the Decision Support Tool, which some people may be aware of, is a tool that has 10 different domains of need, and you are allocated to a level of need in each of the domains. And if you have a certain number of high-level needs, then it's indicated that you'll be eligible for continuing healthcare. But it's not to be used mechanistically. That tool is supposed to be part of the process that's considered at the MDT. But what's actually required is a holistic assessment of need. As it says, if having taken account of all their needs following the completion of the DST, it can be said that the main aspects or majority part of the care they require is focused on addressing or preventing health needs. It's about the level and type of the overall actual day-to-day care needs. No gap in the provision of care. No one should fall between the NHS or the local authority if they meet eligibility criteria. As we can see, and we saw earlier that local authorities can provide services that are incidental and ancillary, health services that are incidental and ancillary to mainstream care services. Now, in terms of looking at questions of eligibility, is these 4 areas of need that end up being considered. So the nature of the need, particular characteristics, whether those are health focused, the intensity, so the extent and severity of the need, the complexity, how the needs present and interact, and the unpredictability, if they fluctuate and create challenges in management. And so those are the 4 areas that get looked at to consider whether there's then a primary health need. So that's all I was going to have time to go through on the main parts of the guidance. What I was also going to look at here is what the guidance says about transition. So we see in this very lengthy index which goes through screening, eligibility assessment, and so on, that there is a section on transition from child to adult services. It's very important. So this framework is used to determine eligibility for those who are aged 18 or over. We see, as I mentioned before, that continuing care means different things for children and adults. Continuing care for children refers to additional health support. And so there will be joint packages for children's continuing care, which doesn't presuppose eligibility for NHS continuing healthcare, but it is a pointer in that direction, I would suggest. ICBs and currently CCGs and local authorities should have systems in place to ensure that appropriate referrals are made when either organisation is supporting a young person who, on reaching adulthood, may have a need for services from the other agency. So that's very important in terms of making sure that people don't fall through the net and don't lose eligibility when they turn 18. As we're seeing, the whole system is predicated on the idea that when you turn 18, nothing should be lost simply for that reason. The needs of a young person and any future entitlement to NHS continuing healthcare should be clarified as early as possible in the transition planning process, particularly if leads are stable. I think that's really, really important, of course. And this is very important. Children's services should identify those young people for whom it's likely that adult NHS continuing healthcare will be necessary and should notify whichever ICB will have responsibility for them as adults. This should occur when a young person reaches the age of 14. So from 14, this kicks in, followed up by a formal referral for screening at the age of 16. And then as soon as practicable after the 17th birthday, eligibility for NHS continuing healthcare should be determined in principle by the relevant ICB, so that wherever applicable, effective packages of care can be commissioned in time for the individual's 18th birthday. So unlike for social care, there isn't this kind of gradualized transition available. There's supposed to be a shift at 18 from children's continuing care, to, if eligible, to NHS continuing healthcare, if eligible. And so people need to be involved in both the assessment and care planning from both sides to ensure a smooth transition, as it says. Initially established entitlement using the decision-making process in the national framework, including the checklist and the DST. Any entitlement by means of those processes before a young person reaches adulthood will come into effect on their 18th birthday, subject to any change in needs, and then a review 3 months after that 18th birthday, and then at least annually. Best interest decisions will be needed, and we're coming on to the Mental Capacity Act in a moment, where there's any dispute about if the young person lacks capacity. And the point about non-eligibility and rights to request reviews. So I think that's all I needed to point out in relation to transition. Oh, here we go. A key aim is to ensure that a consistent package of support is provided during the years before and after the transition to adulthood. The nature of the package may change because the young person's needs or circumstances change. However, it should not change simply because of the move from children's to adult services. So everything is supposed to be person-centered, as you would expect. Right, so before I jump over to the Mental Capacity Act, I'll just look and see if there are any NHS continuing healthcare questions. So if a health area won't get involved until at least 17 and a half, how do you challenge that? It would have to be by way of judicial review, because there's no tribunal here. You can make a complaint, but if it's really urgent and it's serious, then you'll need to get advice about the potential for a judicial review. If a child or young person is assessed as not eligible for continuing healthcare, for children's continuing care, can the application during transition be made for continuing healthcare? Yes, very much so. But you need to wait. Well, you could apply, you can ask for a referral in accordance with the transition process that I've just outlined. If the decision is negative, then you can ask again once they've turned 18, and there would be a adult checklist applied, and the usual adult process will go through. Does continuing care cover ADHD, autism, mental health, etc.? Potentially, yes. So if you look at the domains of need, they will include things like communication and behavior. As the guidance has made clear, the diagnosis of the particular condition should not determine eligibility. It's about how the needs manifest. What types of health need would be covered under a joint package of care? Anything that's additional to things you can normally access through a GP or for primary care. So, for example, an element of nursing care. Just a reminder again, if I could ask people to refrain from putting comments in the Q&A, because it's making it harder for me to see the actual questions that people are asking. Should CHC funding only meet health needs or health and social care needs? I think I've made that clear, that if you're eligible for continuing health care, then the NHS should be meeting all of your needs. Asking if any notes or transcript of the meeting is made available. I'm not sure about that, but as I say, the recording should be on the Seashell Trust website. A very interesting question about how CCGs at the moment, what will be ICBs, deliver continuing healthcare, and question about whether or not a person will, an NHS body will fund supported living as opposed to more institutional settings. The answer is they should. And the Equality and Human Rights Commission threatened to judicially review a whole number of CCGs a while back who had seemed to have policies that favoured care homes or nursing homes ahead of funding support in the person's own home or in supported living. And none of those CCGs were willing to defend any policy of that sort once challenged by the Equality and Human Rights Commission. And I would say they were well advised not to do so. So yes, if you're told, well, we only fund up to a certain cap, we only fund certain types of support, then again, individual legal advice is going to be required. I should have said earlier, of course, and I'm sure it's understood that nothing that I'm saying today is to be taken as legal advice. I'm giving a general steer as to the law. A couple of other questions that have come in that I think I can deal with appropriately now. Question about an education, health and care plan that provides for education otherwise than at school, EOTAS. Can that continue post 18? Yes, it can. And indeed, it would have to if it's accepted that that's the appropriate way to meet needs, because the test for an EOTAS package is that it will be inappropriate for the provision to be made in school or college. So the fact that a person's turned 18 shouldn't impact on that at all. Question about hourly rates. As I've said before, it's not, in my view, going to be lawful for either a local authority or a health body to have a cap, a fixed hourly rate. The maximum that they will fund is X. If the needs can be met at or below that level, there's no issue. But if the person's needs cannot properly be met at £9.50 an hour, for example, then it must be right that the public body will fund the actual cost of meeting those needs. And if you're told they won't, then it's certainly going to be sensible to seek individual advice. A few more questions that have come in. Issues around medication and refusals, age-related refusals to give medication. Again, although those are matters of clinical judgment, and clinical judgment, a bit like educational judgment, is hard to challenge legally. If you've got a blanket policy that stops something at 18 and that's not indicated clinically, i.e. the medication is supposed to be available for over 18s, it's supposed to be effective for over 18s, then it may be possible to judicially review that policy. There would have to be a rational and lawful justification for that kind of hard-edged blanket policy. And so people, again, will be well advised to get specific legal advice. An interesting question about refusing to include transport costs in personal health budgets by reference to the people having the mobility component of personal dependence payments, PIP. That's definitely something that, again, people should be seeking advice on if, as I imagine is often the case, in fact, they haven't got the money that they need to fund their transport. Does CHC funding automatically follow a person when they move local authorities? Not necessarily, because again, it would be open to the new area to do a new assessment for continuing healthcare and conclude the person's not eligible. But very often it's obvious that they are eligible. And if you've had continuing healthcare for a significant period and you move areas, the expectation would be that you would continue to be eligible, but it's not a guarantee because different professionals will, of course, reach different views. Do you lose your social worker if you qualify for continuing healthcare? A really interesting question. You're not entitled to a social worker under the Care Act either, but it is likely that if you do have a social worker allocated to your case, then you will not continue to have that social worker if you're eligible for continuing healthcare, because the adult social care team no longer have a role in providing your care. If you're receiving a high care package at 17 from continuing care, children's and young people's continuing care, if you're looking at residential care post-18, would social care contribute? It would depend whether the person then becomes eligible for adult continuing healthcare. Because again, if adult continuing healthcare eligibility is indicated, then there's no role for adult social care input. Should the person who's representing the young adult be present when the DST is done, especially if the young person has complex needs and lacks capacity? I think that's a really, really great question. Yes, I think so. Certainly there should be a meeting to discuss the decision support tool. And I've been involved in some of those. Unusually, my clients are very often involved in them. It would seem quite obvious to me that an advocate, family member should be involved if the young person isn't able to be involved themselves. And any refusal to allow that, again, is capable potentially of being challenged by way of judicial review. Thanks very much for all of those questions. I'm going to move on now for reasons of time. Apologies for those that I haven't yet had a chance to answer. I may be able to answer a few more in just a moment. Let's look now at the Mental Capacity Act. What have we got there? 45 minutes on the Mental Capacity Act. Not really enough, but I can at least do some headlines. So I'm just going to close. Actually, no, okay, we may need some of them again. I'll take away the national framework. So look up the Act itself. Again, just search the title. So it's from 2005. You can put that in as well. Go to legislation.gov.uk. And we see that the Act is about persons who lack capacity. And so before the Mental Capacity Act, this is all dealt with under some fairly obscure pieces of case law. What the Mental Capacity Act did was to bring together all those principles from the common law and set out much more clearly how we approach the difficult question of deciding who can make decisions for themselves, and then what to do about situations where a person is assessed not to be able to make a decision for themselves. So we start with the principles, which are fundamentally important, always need to be taken into account in any case. And we see, okay, am I on latest available? Let's see. The following principles apply for the purposes of this Act. So anything to do with the Mental Capacity Act. A person must be assumed to have capacity unless it's established that he lacks capacity. So that's absolutely fundamental, the presumption of capacity, that as soon as a person turns 16 and this scheme applies to them, the starting point is that they can make decisions for themselves about everything. And if someone wants to say, whether that's a parent or a professional, I don't think that Johnny can decide where to live or what to eat or whether to have contact with this person, then they need to evidence that. Burden is on that person to establish that they lack capacity. We also then see the person is not to be treated as unable to make a decision unless all practicable steps to help him do so have been taken without success. So there's a very high duty there, all practicable steps, everything that's practicable to help the person make the decision for themselves. And a person is not to be treated as unable to make the decision merely because they make an unwise decision. So that's really challenging, I think, in practice, that we have to allow for a space between a person who is unable to decide and a person who makes a decision properly, but which we don't agree with, which we think is foolish, which we think is silly. Because if they are able to make that decision, all of us have a right to make unwise decisions in our lives. So we're not allowed to hold disabled people to a higher bar, higher standard in terms of the quality of decision making than the rest of us are held to. So those principles are all around capacity. Then we move on to best interests, the principle that any act done or decision made under the Act, under the Mental Capacity Act, on behalf of a person who lacks capacity, must be done or made in their best interests. And before that decision is made or the act is done, we must consider whether the purpose for which it's needed can be as effectively achieved in a way that's less restrictive of their rights and freedoms. So we've got to focus on what we're trying to achieve and then ask, can we do this in a less restrictive way? So that's the principles in section 1. What does it mean to lack capacity? So the definition is here in section 2. The purposes of the Mental Capacity Act: a person lacks capacity in relation to a matter. So that's really important. So it's decision specific. If at the material time, so it's time specific as well, people's capacity can change. It can get better. You can become more able to make decisions for yourself. Certainly that will be true of many disabled young people. Of course, for those perhaps with dementia, older people, they will become less able to make decisions for themselves over time. So if at the material time they are unable to make a decision for themselves in relation to the matter, so again, focusing on the particular decision because of, so this causal link, an impairment of or disturbance in the functioning of the mind or brain. So the first question we have to ask ourselves is, can the person make the decision? And then we have to say, is it because of a disability, essentially a disturbance in the functioning of or an impairment of the mind or brain, no matter whether permanent or temporary, as it says here. Mustn't just refer to a person's age, their appearance, any diagnosis they have, or any behavior. You've got to always go through the right test. And it's decided on the balance of probabilities. So more likely than not, 51%, of course. And here's the point about the threshold being 16. So no power that could be exercised under this act is exercisable in relation to a person under 16, subject to some minor exceptions. So that's what we've got to ask ourselves. Is the person able, or here unable, to make a decision for themselves? And then section 3 tells us what being unable to make a decision means. For the purposes of section 2, persons unable to make a decision for themselves if they're unable to understand the information relevant to the decision. This is really important and is often ignored. What we have to work out is, in relation to the decision in question, what's the relevant information that someone needs to understand? And I may have time to show a guidance note on this that's produced by my colleagues in 39 Essex Chambers, which goes through the case law on what information is relevant to what types of decision. But if the person isn't given the relevant information and asked questions about it, then they can't be said to lack capacity in terms of being able to understand the relevant information, because no one's worked out what the relevant information is. So that understand point is very often going to be highly relevant to disabled young people. Retain the information may be relevant, but you've only got to be able to retain it for long enough to make the decision. And so unless you've got some kind of very significant mental health problem, perhaps, it's unlikely that retention of the information is going to be the relevant area. If you're able to understand it, you're probably going to be able to retain it, because the issues around retention, of course, are going to be much more prevalent in relation to people with dementia, for example. The third limb, though, is highly relevant for our cohort: to use or weigh that information as part of the process of making the decision. Use or weigh. So if you're able to understand the information, then the next stage is, and retain it for long enough to make the decision, are you able to put it in the balance and then make a decision? And you can immediately see how this then links to the principle that people are allowed to make unwise decisions, and no one can be said to lack capacity merely because a decision they're proposing to make is unwise. There is a distinct difference in law between a person who is unable to use or weigh up the relevant information as part of the process of making a decision and therefore lacks capacity, and a person who is able to use or weigh up the information, but then makes a decision that everyone else thinks is off the scale, wrong, who is able to do that and has capacity, and that capacity should be respected. Working out where that line is can be very difficult in practice, but in law, it's a very clear, very hard-edged line. And then the final limb must be really carefully understood: to communicate its decision, whether by talking, using sign language, or any other means. This is essentially about people with locked-in syndrome. So if you can understand, retain, and use or weigh the information, and if you're not in a coma or locked in, then you are almost certainly going to be able to communicate it, even if it's only by your behavior. So it's very, very unlikely that that's going to be the relevant limit of the test. It's almost always, in our case, it's going to be A and or C, and possibly B. And you're not to be regarded as unable to understand the information relevant to a decision if you're able to understand an explanation of it given to you in a way that's appropriate to your circumstances, using simple language, visual aids, etc. So this links to the all practicable steps obligation. We have to help people to understand the relevant information before we can assess that they lack capacity. And then, as we've seen, the fact you're able to retain the information for only a short period doesn't prevent you from being regarded as able to make the decision if you can retain it for long enough to make the decision. So that's the base. Oh, sorry, I should focus on 4 as well. This is very important. The information relevant to a decision includes information about the reasonably foreseeable consequences of deciding one way or another, or of not making the decision. So if I've got a gammy leg and I don't make a decision about whether to go to the doctor or not, the reasonably foreseeable consequence is that eventually I may need to have my leg amputated. So you need to think about not just the immediate consequences, but the reasonably foreseeable ones as well. What may happen in the reasonably foreseeable future? So that's in very, very headline terms, the tests for capacity. Let's assume the person lacks capacity. Where do we go next? Well, we go to section 4 and we look at best interest decision making. So in determining what's in a person's best interest, the person making that decision must not make it purely on the basis of their age, appearance, condition, or behavior. So you have to put those things away. At least they cannot be determinative, because this is merely on those bases. But you must instead consider all the relevant circumstances. So no one area dominates in terms of best interest. You've got to look at the matter in the round, and in particular, do these things. You must consider whether it's likely the person will have at some point have capacity, and if so, when. You must, as far as reasonably practicable, permit and encourage the person to participate or improve his ability to participate as fully as possible in acts and decisions. You're not allowed to be motivated by a desire to bring about a person's death if you're dealing with life-sustaining treatment. Fortunately, that's not going to be the majority of the decisions. And you must consider, so far as reasonably ascertainable, the person's past and present wishes and feelings, and in particular, any relevant written statements, beliefs and values that would be likely to influence the decision if they had capacity, and any other factors he would be likely to consider if he were able to do so. And so this concept about looking at the person's own values and views has been given increasingly greater prominence in the case law on best interest decision making, particularly since the Supreme Court's judgment in a case called Aintree University Hospitals and David James, where Lady Hale gave a very important judgment saying we really do need to focus on what matters to P, as they're referred to in the Mental Capacity Act, to that person. And essentially that what they want, what the person who lacks capacity wants, should be the starting point. It may not be the end point, because they may not know what's best for them. That's the whole point. But we certainly should start from the presumption that we will try to do what the person wants in accordance with subsection 6. You must also, as a decision maker, take into account, if practical and appropriate to consult them, the views of anyone named by the person, anyone engaged in caring for the person or interested in his welfare. And so that would bring in, of course, family members, parents, siblings, everyone else. Donors of a lasting power of attorney, what's that? We'll come back to that. And equally, any deputy, come back to that as well. And importantly, you comply with this section if you reasonably believe that what you do or decide is in the best interest of the person concerned. So that's what you have to have, a reasonable belief, which means that you have to have gone through this process and worked out what you think is in the person's best interest. And that's then picked up again in section 5. So we'll skip over deprivation of liberty for and come back to that. Because section 5 provides a defense, or what's often described as a general authority, that if a person does an act in connection with the care or treatment of another of P, and if before doing the act, they take reasonable steps to establish whether P lacks capacity in relation to the matter, and they reasonably believe that P lacks capacity and it's in their best interest for the act to be done, then there's an exclusion of any liability in relation to that act in the same way they would have if the person had capacity and had consented to it, as long as we see here, they're not negligent. So the vast majority of decisions and acts are actually done under this general authority in section 5. Best interest decision making is you are relying on section 5 of the act. Where there's a dispute or where there's a particularly significant decision, then applications can be made to the Court of Protection to resolve the question of what's in the person's best interest. So let's step back for a moment and think about what the Court of Protection is. So it's the court for the Mental Capacity Act, and it takes the decision about, firstly, whether the person lacks capacity, applying the balance of probabilities on the evidence. Does the person lack capacity? And if they do, then what is in their best interest? Again, hearing all relevant parties and considering all the evidence. Also, the court can resolve disputes in relation to lasting powers of attorney. And so what the Act does is create the power for a person to donate, to give power of attorney in relation to either personal welfare and or property and affairs. Now, once you've given that power of attorney, and assuming it's all valid, then your attorney, your LPA, will have the authority to make decisions on your behalf. But this is only relevant where at the time of giving the power of attorney, you yourself have mental capacity. So it's for future loss of capacity. Of course, for most disabled young people, the issue is they don't have capacity at the relevant time, so that the LPA system isn't available to them. And that's where we get into the concept of deputyship. So the Court of Protection can appoint a deputy under Section 16 to make decisions on P's behalf in relation to the matter or matters. So that's how the court can either do it itself, make an order to make the decision on P's behalf, or appoint a deputy. And the court will do that very regularly in relation to property and affairs. So if there's an issue in relation to the management of P's funds, their home, property, whatever it might be, then the court will quite regularly appoint a suitable person, a family member or other, to be the deputy to make those decisions. But it's much less keen to appoint personal welfare deputies. So you certainly don't need to assume that just because your young person is approaching 16th birthday, you need to become their welfare deputy, unless there's a good reason, essentially. That's what the case law says. And that's because, as we see here in subsection 4, when deciding whether it's in P's best interest to appoint a deputy, the court must have regard to the principles that a decision by the court is to be referred to the appointment of a deputy to make a decision. And so because of that exclusion and restriction, you need to get around that and say, well, nonetheless, this is a case where a personal welfare deputy should be appointed. So for example, I had a case where an autistic young person needed a series of medical interventions, all of which had benefits and disbenefits. And everyone agreed that his mother was best placed to decide whether they were in his best interests. And so she was appointed by agreement as the personal welfare deputy for her son, in order to give her the authority to make those decisions and to consent or otherwise to the treatment. But what wouldn't have happened is that if there was a dispute about whether or not these treatments were a good idea, it's very unlikely the court would have appointed a deputy, because instead it would have said, well, no, we will decide in accordance with 16.4 whether in each case the operation should go ahead. Applications will need to be made to the court at the relevant time if you can't all agree, or if the intervention is sufficiently serious that the guidance says it's the kind of decision the court should make. So deputies are only to be appointed where it's needed, where it's good reason for it, essentially. And there'll be a new code of practice for the Mental Capacity Act soon. And I know that there's been some analysis of what that's going to say about personal welfare deputies, but I'm afraid I haven't had a chance to read that yet. So if you follow my Twitter feed, I'll try and say something about it on there. So that's the concept of deputyship. Very powerful authority if you have a deputyship order in your favor to make decisions on behalf of, for example, your son or daughter. But the court will not just grant these without good reason. And so again, no point making an application for personal welfare deputyship unless you've got advice that yours is the kind of case that is likely to be granted. Just another important point about the way that the court works. If you make an application to the Court of Protection, the court will apply what's described as an interim threshold in terms of holding the ring. So you can go to court and ask for interim orders and directions to be made here under Section 48. And they will do that if there's reason to believe that the person lacks capacity. So that's quite a low bar, but there has to be some evidence. And it's in his best interest to make the order or the direction. So an interim order or declaration can be made to protect P, essentially, or to protect P's interests if there's reason to believe they lack capacity. And then, of course, one of the key questions for the court will be, right, what's the evidence going to be that will help us make the decision as to whether or not P does, in fact, lack capacity? So there's lots more in the MCA, which I may have time to come back to, but I want to have a look again at the questions and see what's come in on capacity or any other issues. So the difference between a deputy and an appointee. So an appointee is outside of the Mental Capacity Act scheme, and the appointee is someone who is only appointed to manage a person's welfare benefits. So if all they have is a welfare benefits coming in, then the Department for Work and Pensions can appoint someone as the appointee to manage those. So you won't need to be property and affairs deputy. If there's other assets of any kind, other income, other savings, other capital, property, real property, whatever it might be, then you may need to be property and affairs deputy to manage those for the person. So in terms of what's the likelihood of being appointed as welfare deputy, I think it's really quite difficult, because people often want to be appointed as a welfare deputy in situations where there's been conflict, and because they're saying, well, we've been ignored, our rights haven't been respected. And ironically, to some extent, of course, it's the fact of conflict that may well result in a non-order for welfare deputyship, because it's not supposed to be a way of giving one particular party the upper hand in decision making. And what the court will say instead is, well, if the processes of the Mental Capacity Act aren't being respected, then you can potentially bring an application for judicial review, but perhaps more practically, just come to court, make an application to the Court of Protection, and ask the court to decide whether the person lacks capacity and or whether the relevant question is in their best interest or not. So you don't need, and you won't get, welfare deputyship, I'm afraid, as a result of conflict. In fact, it's likely to point the other way. A question about a need for a particular intervention. Given as an example is a cochlear implant. Would you need welfare deputyship for that? Really good question, because the answer is probably not, because that's the kind of decision that if the person lacks capacity to make themselves about their health, then it could be decided on a best interest basis. Or if the doctors and others don't feel that that's appropriate, an application can be made for a specific order from the Court of Protection that implant is in the person's best interest, and you wouldn't need to be a welfare deputy in that context. How do you get a capacity assessment? Really interesting question. Well, of course, you shouldn't need one unless someone is going to come along and say that you lack capacity to do something. So if I'm a disabled young person, I just merrily go about my life making my own decisions, unless and until someone comes along and challenges my ability to do so. Of course, for some disabled young people, it's really obvious they don't have capacity. And in that context, if there needs to be a formal assessment of capacity, then it's about the relevant decision maker making that assessment. So, for example, in relation to where the person's going to go to school, it will be the local authority's Director of Education formally, but perhaps a more junior officer of the local authority in practice. It's very clear that it's for the decision maker to decide whether or not a person has or lacks capacity. But in many cases, it will be appropriate for them to get advice from an expert. And that could be a medic, could be a psychiatrist, could be a GP. It doesn't have to be, though. For example, social workers are able to assess capacity under the Code of Practice. And what they'll need to do is ask all those questions that we've seen in sections 2 and 3 of the Act. So in particular, does the person understand the relevant information? Can they retain it long enough to make the decision, use or weigh it up, and communicate it? That involves, of course, first of all, identifying what the relevant information is. And so that guidance from the expert will inform the decision of the decision maker as to whether the person has capacity themselves, or if a best interest decision needs to be made. Would a parent carer usually be informed that a best interest decision needs to be taken? Yes, I would think so, because as we saw in section 4, section 4, which I lost for a moment, there we are. In making a best interest decision, a decision maker must take into account as a duty, if practicable and appropriate, and that, why wouldn't it be? Well, if there was a reasonable grounds to suspect abuse or neglect, perhaps, but all things being equal, it will be practical and appropriate to consult a family member, the views of anyone engaged in caring for the person or interested in his welfare. So if a parent, for example, isn't told that there's a best interest decision-making process going on or about to happen, how can the decision maker comply with this duty here in 7B? Because they won't have taken into account the views of the parent, the person who's engaged in caring and concerned about the person's welfare. So a question I think has probably been answered, but I'll use to reiterate the point. If a young adult lacks capacity, is it wise to apply both for deputyship for health and welfare and property and finance? No. As I was saying before, you'll need good reason to apply for health and welfare deputyship. Would you do it without legal support? You can quite possibly apply for property and affairs deputyship without legal support. Many people do. Of course, the risk is you might get something wrong and then it gets sent back by the Court of Protection, and that makes things slower. But it's not certainly not necessary to have a legal professional involved in a property and affairs application. I would generally say if you're applying for welfare deputyship, it does make sense to take advice. You'll need someone to look at the leading case of Re Mottram and go through and try and explain why, in the light of that judgment, it's necessary for a welfare deputy to be appointed. And that's quite difficult, I think, for people to do without access to specialist advice. So who can provide an accepted diagnosis of a lack of capacity? Is an interesting question. Well, of course, it's not diagnostic, because having an impairment of or disturbance in the functioning of mind or brain is just one part of the test. And we don't just refer to the diagnosis, of course. But the Code of Practice says that there's a whole range of people who can provide advice: social workers, psychologists, psychiatrists, GPs, etc. But ultimately, the person who has to decide whether or not the person lacks capacity is the relevant decision maker. It might be a family carer, but may well be a social worker or an education professional, depending on the kind of decision that is needed. Going through some questions that I definitely have answered. If there's anything else. So is a property and affairs deputyship generally required for a young person who has a long-term mental disability where they've got no significant assets in their name but receives the normal suite of benefits? No. So in that case, that's exactly where appointeeship is the right process, because it's cheaper, essentially, and you don't need to make an application to the Court of Protection. It would only be necessary to become property and affairs deputy if there are assets above and beyond the usual suite of welfare benefits. And the case in terms of providing guidance on when you can become appointed as a welfare deputy is called Re Mottram, M-O-T-T-R-A-M. In fact, let's see if I can bring it up, since we are obviously concerned about that issue. Here we are. There were a number of joined cases, and what happened in that case was that the Vice President of the Court of Protection, Mr. Justice Hayden, used an opportunity to clarify the correct approach for determining whether a welfare deputy should be appointed, because the Code of Practice said, and says, I think, until it's taken away, that should only be in the most difficult cases, which seemed like a very high bar indeed. And the judge said, no. The starting point, though, is look at the Act. No special alchemy that confers adulthood on an 18th birthday, but it does mark a transition to an altered legal status. And so we have to be very careful not just to allow parental responsibility to roll over post the 18th birthday. And he says that it may well mean the most likely conclusion in the majority of cases will be that it's not in the best interests of P for the court to appoint a personal welfare deputy. Not a statutory bias or a presumption against appointment, it's the likely consequence of the application of the relevant factors, not a starting point. Code of Practice is only an interpretive aid. There's only one presumption in the Mental Capacity Act, that this person is assumed to have capacity unless established they lack it. So we don't presume that a deputy will or won't be appointed. And so the summary that my colleagues came up with is the Code of Practice is wrong in saying that it's only for the most difficult cases. Each case is decided on its merits. What he wants will be an aspect of the decision, but in practice, personal welfare deputies will not often be appointed. So it's not the case that appointing a deputy is necessarily in and of itself less restrictive of P's rights and freedoms. A deviation from the ordinary decision-making structure set up under Section 5 of the Mental Capacity Act, i.e. best interests and reasonable belief, has to be justified. So it's necessary to explain in any application for appointment as a personal deputy why the collaborative and informal decision-making structure of the Mental Capacity Act is put in place has not been serving P's interests. So I hope that's helpful as a bit of guidance on that very important issue. If a social worker has made a judgment that a person lacks capacity, is that decision then registered with the Court of Protection? No, absolutely not. Court of Protection doesn't register decisions as to whether a person has or lacks capacity, because of course that decision itself may change over time, one way or the other. It's something that needs to be kept constantly under review, because the Act talks about the material time. So if there's a situation where a series of decisions need to be taken, each time the decision is taken, we need to look at, again, at the question of capacity. Now, it's got to be realistic. Nothing's changed, then it may be completely OTOs to do we wouldn't necessarily need to do a full capacity assessment again. But any possibility that the answer might change should result in those 4 questions in section 3 being asked and answered. Should the professional making the capacity assessment have knowledge of the condition affecting the person? Yes, absolutely. And the fetal alcohol syndrome and frontal lobe paradox and issues around executive functioning are very much at the forefront of the real difficult questions about capacity assessment. So yes, absolutely, any assessment needs to be done by someone who is properly appraised of the relevant condition. If medical interventions have been previously really in the best interest of the child to be carried over into adult services, could that be done on a person's best interest? Yes, it could. But there's guidance on serious medical treatment issues, and some of those cases need to go to the Court of Protection just as a matter of course. And so the doctors and their advisors will know, or should know, which cases essentially can't be, in practical terms, just dealt with on a best interest basis and have to go to the Court of Protection. And so it's really important that you ask that question if you're not a doctor, but you are concerned about these issues. But if it's in the best interest of the child and nothing's really changed, it may well be that it's in the best interest of the adult as well. About a very interesting and important question for young people in transition to adulthood is about supported living. How is the housing agreement managed or signed? It can be done on a best interest basis. So tenancy agreements can be entered into, and it may be necessary to get the Court of Protection to authorize someone to do that. And certainly it can authorize personal welfare deputies, property and affairs deputies to enter into tenancy agreements. That's one thing the property and affairs deputies can be given the power to do. So there is a mechanism to allow a person who lacks capacity to sign a tenancy and therefore to be able to benefit from supported living. Does an assessment of capacity need to be updated regularly? Well, yes, it does. I mean, unless in an extremely rare case, literally nothing changes in the person's condition. But I would say that's very unlikely. And so in the majority of cases, it is going to be necessary to ensure that capacity assessments are revisited regularly, because otherwise there's a real risk that we won't be looking at the material time. A question that goes back to the discussion before about continuing healthcare: does the CCG or the ICB, as it will be, also need to comply with the Care Act duties? No, the Care Act duties are specifically directed at the local authority, and it is quite interesting, I think, therefore, that CCGs and ICBs don't have the wellbeing duty in Section 1 of the Care Act. There is wording that goes in a similar direction in the national framework, but they don't have the same kind of clear statutory duty that local authorities have. Okay, now a question has come in that's really important about restrictions in terms of leaving the home, locking the front door, and so on. And that brings us on to the thorny question of deprivation of liberty, which you may have spotted as I was going through the Care Act. We had some discussion, the Mental Capacity Act, with some considerations here in sections 4A to 4C. So just stepping back, Article 5 of the European Convention on Human Rights is the right to liberty, and it reflects the right that we've also got in the common law. Essentially, there should be no deprivation of a person's liberty unless one of the very specified list of examples applies. And so the first question that we need to answer is, well, what is a deprivation of liberty? And the Supreme Court told us the answer to that question in a very important case called Cheshire West, known as Cheshire West, and it's Cheshire West MP and Surrey County Council were the other public authority involved. And what the Supreme Court said in Cheshire West is that there is no difference in what constitutes a deprivation of liberty for disabled people than for anyone else. It doesn't matter that what's being done may be done with the very best of intentions or even the very best of outcomes, because a gilded cage is still a cage. And so we look at 3 factors to identify if a person is deprived of their liberty. And those are, firstly, the objective element, that you have to be confined to a particular space for a not negligible period of time. And so we're looking there at whether the person is free to leave in real terms. Can they go, not come back? And if while they're there, are they subject to continuous supervision and control? If the answer to those questions is yes, then they're deprived of their liberty as opposed to merely having a restriction of their liberty, objectively. And then the subjective element is that they're not able to agree to consent to it themselves, so that they lack capacity to consent to that arrangement. And the third then is that it's imputable to the state, but that's a very low bar indeed. Even private arrangements in people's own homes, where the state knows or ought to have known about them, would be imputable to the state. So really the key question is very often going to be, objectively, does it reach the level of being a deprivation of the person's liberty? And if it does, then what's required is lawful authorization for that. And often that can be granted now, currently, under the deprivation of liberty safeguards. And that brings in this term DOLS that people may have heard about. They are the deprivation of liberty safeguards. And under the DOLS regime, local authorities can grant authorizations for deprivations of liberty, but only in hospitals and care homes, and only for those aged over 18. Now, of course, that instantly rules out a very large number of the young people we're talking about who are either 16 or 17, or who are not happily in a hospital or a care home. And so the liberty protection safeguards, the LPS, that are going to replace the DOLS relatively shortly, do allow for authorizations for 16 and 17-year-olds, and do allow for authorizations in a wide range of settings, not just in hospitals and care homes. So we should see more cases for our young people where any deprivation of liberty is authorized under the DOLS. Until that comes in, it's only the Court of Protection that can grant those authorizations. And there's a streamlined process for applications for authorization where it all seems to be in order and there's no real contest. But the court, interestingly, is pulling out from that streamlined process, what's known as the re-ex procedure, applications in relation to 16 and 17-year-olds, and saying, no, those need to be carefully considered. So deprivation of liberty is a really important point, and where young people have significant needs and where there are significant restrictions on them, then it needs to be considered whether they are in fact deprived of their liberty. And if they are, then it needs to be authorized. Otherwise, there's a breach of their human rights, which can sound in very significant amounts of damages. If it's a material breach, if as a result they are suffering a detriment, they are somewhere they shouldn't necessarily have been. But there's a risk, I think, that deprivation of liberty can completely swamp the whole discussion about mental capacity and about human rights for disabled young people as well. And I have to say that if I had to pick a human right to focus on, I wouldn't pick Article 5. I'd pick Article 8, which is the right to respect for family and private life, and in particular, the private life limb of Article 8 that protects disabled people's physical and psychological integrity, their ability to function socially, essentially their well-being, is, I would say, rather more important generally than the narrow right to liberty that's protected by Article 5. And so just because you are not deprived of your liberty doesn't mean that you're having care, receiving care that respects your human dignity, for example. So I wouldn't want all of the focus of any discussion around human rights to be on the rights that are protected by Article 5. So I hope that's helpful as an answer to that question. Okay, anything else? Just giving people a chance to ask any last questions, and I'll look through the list. But before we end, I think I've answered the question that's in here about supported living lacking capacity, the fact that tenancy agreements and other housing agreements can be signed on the person's behalf, and the Court of Protection Authority may need to be given to that. Guardianship, just to mention that's a Mental Health Act construct, which we haven't got time to go into today in any detail. The difference between that and power of attorney, of course, is that people choose to make power of attorney. I think what may be intended by that question is deputyship, which is, as we've seen, the mechanism under the Mental Capacity Act, which focuses on those who don't have capacity to give away their decision-making rights through making power of attorney. Anything else I need to look at here? Answer the question, I think this here about, do you need to apply for power of attorney when the child turns 18? No, if you make any application, it will be deputyship. You can make it from when they turn 16, and the probability is you'd only want to apply for property and affairs deputyship if there's resources to manage. Okay, so just before we end then, let me go to, in the last instance, to the Children and Families Act. Just talk a little bit about EHC plans and ceasing to maintain. That's probably the last bit of the key bit of the jigsaw that we haven't yet looked at. So I'm going to rush through this bit, of course. People will be aware under the Children and Families Act that where it's necessary for special educational provision to be made in accordance with an EHC plan under section 37, that's what will be made. But we know, of course, the local authorities don't have to maintain the EHC plan forever. And the test in section 45 is that they may cease to maintain the plan if they're no longer responsible for the child or young person. Of course, they may become too old, they may move away, or it's no longer necessary for the plan to be maintained. So that's the legal test. That includes where the child or young person no longer requires the special educational provision specified in the plan. So the focus, as always, under the Children and Families Act is on education. And in making that decision, the local authority must have regard to whether the educational or training outcomes, educational and training outcomes have been achieved. So it's really important that for older young people, the outcomes section of the plan is good, is proper, and does actually reflect the outcomes we're looking for, because that will be a large factor in determining whether or not the plan will continue to be maintained post 18. Importantly, as we see here in, I think it's here in section 51 in terms of appeals to the tribunal, that one of the things you can appeal against is a decision to cease to maintain the plan under section 45. I think perhaps it's in the regulations. Anyway, it's very clear that the law requires that if you do appeal against that decision, the local authority must continue to maintain the EHC plan while your appeal is going through. So that acts as a safety net. And when you appeal, if you do, against the decision to cease to maintain, you can also ask the tribunal to rewrite the plan in the same way as you would do if you were appealing against an initial plan or a plan and an annual review. So there is an important safeguard there, but it is the case, of course, that although EHC plans can continue to 25, they don't have to, and they will be ceased at the point the local authority decides, in particular, that it's no longer necessary in terms of the delivery of special educational provision. So you may need to evidence that there is ongoing educational need, and important principles from the case law that says that we don't have to measure that by reference to particular qualifications, that the levels of progress that the young person may be making may be quite small, but there has to be some evidence of an ongoing educational need if the plan is going to continue. So you can have the most complex health or care needs, and the plan will still be ceased if there's no educational needs that justify its continuation. A really good question that's come in, I'll take perhaps one of the last ones, about children and young people who are also eligible under the leaving care provisions. So if you've got a disabled child, young person, who's been accommodated by the local authority under section 20 of the Children Act, and that's for a minimum period as specified in the Act, or if they're subject to a care order in favour of the local authority, they will become what's called a former relevant child when they leave care at 18, and they will have entitlements to a personal advisor and a pathway plan, and that essentially sits on top of all of these provisions. So as well as all of the education, health and social care entitlements that they accrue as a result of being disabled or having special educational needs, they will also have these additional entitlements to ongoing input from the local authority's leaving care team as a result of them being a looked after child when they were a child. So it's not a replacement for any of what I've discussed today. It's an extra set of entitlements in terms of making sure that that all of this is properly coordinated, and there's a focus on securing outcomes generally for them in adulthood in the way that natural parents are expected to do for young people in the modern age, well beyond their 18th birthday. So sorry, that's a whistle stop answer to a very important question, but yeah, that's all I've really got time for today. Thanks ever so much, everyone, for all your questions. Been really, really good, as always. I hope it's been a useful steer as to this very interesting and complex area of law. And I do hope that the chapter of the handbook gives you a lot more answers in this area. And of course, you'll see some points about transition to adulthood in other chapters around education, housing, etc. as well. But it's really this chapter 10, that hopefully provides an overview and goes through all the things that I've been talking about today, including I haven't talked about higher education in any great detail either. That's there at the end of the transition chapter. Thanks very much, everyone. I'll hand back now to the organisers to close us off.
Right, thank you, Steve. I hope that everybody found the discussions in today's webinar useful. As Steve mentioned, a recording of the session will be available on our Seashell YouTube channel from early next week. We'll also be sending out a survey to everybody who's attended today's session. Please do give us your feedback, as this does help us to improve the webinars and the training sessions we provide. Today's session is the last webinar that Seashell Family Services will be providing before the summer break, and also the end of a very nice little run that we had with Steve providing, but we will hopefully get him back again in the future. Please can you check the What's On section of our website at www.seashelltrust.org.uk for any upcoming events. So thanks again to Steve, and thanks everybody for attending today's session. We hope to see you all again soon. Thank you.
Thank you. Thanks for having me, Seashell, and everyone involved. It's been great.
Thanks, Steve. Take care, everybody. Bye.
Bye now.